Welcome, everyone. My name is Marina, and I'm here with my colleague, the team leader of the human rights team, Sofia Sutera. Right now, today, we are going to interview Davide Colombi on the topic of the new return regulation recently approved by the European Parliament. Migration and return policies remain among the most contested areas of European policymaking, where states' efforts to manage migration intersects with their obligations to uphold fundamental rights and international legal standards. On June 17, 2026, the European Parliament approved the new return regulation, marking a significant development in the European legal framework on returns. The reform introduces new measures concerning detentions, obligations placed on individuals subject to return procedures and cooperation with third countries, prompting renewed debate on how the European Union can balance effective migration governance with the protection of human rights. In this episode, we will examine these developments and discuss what the new return regulation could mean for the future of the EU migration policy, the rights of the people affected by return procedures, and the broader human rights implication of this evolving framework. Today, we are joined by Davide Colombi, a researcher in the Justice and Home Affairs Unit at the Center for European Policy Studies in Brussels. His work focuses on EU migration and asylum policies, international human rights laws, and the protection of fundamental rights. He has contributed to numerous studies for European institutions, including the European Commission and the European Parliament, and has previously worked with organizations such as UNICEF and the UN Special Rapporteur on Extreme Poverty and Human Rights. Davide, welcome and thank you for being here.
Thank you so much. It's a pleasure to be here.
Thank you. Over the past months, you have published a series of articles at the Center for European Policy Studies analyzing the new return regulations and the debate surrounding it. Today, we would like to draw some attention on your findings and explore this new framework and what it would mean in practice, particularly from a human rights perspective. So in your latest work, you make an important point about many people being undocumented, not necessarily by crossing the borders irregularly, but because of administrative changes, loss of employment, changes in family circumstances. So how should the European migration system better recognize these human realities and prevent people from falling into these situations?
Yeah, so first of all, I would emphasize that this is not necessarily my own argument. It clearly builds on a significant body of existing research, and most recently on our participation as SAPs in an EU-funded project called iClaim that looked at the production of irregularities specifically. And in general, what I would say is that in most countries within Europe, we look at undocumented migrants as people who have crossed the border irregularly or as people who um, have not had their asylum application recognized. But actually, what we've seen in the project, but also more broadly, is that a lot of the people that end up without the right status or the right papers to be in Europe, actually, they come to Europe in a regular way as tourists, as workers, as family members of other people. However, then because of a change in their own conditions, either their families, their work, etc., or other external factors, they might not be able to renew the permits that they have, or they might not be able to change the status because this is not so easy in many different member states. So, for example, this is the case when a residence permit is tied to an employer, but then somebody loses their job and they cannot switch employers, or they might not be able to switch labor sectors in which they work, or for example, there might be some delay in the renewal because of administrative reasons, or again, if they're based on family, maybe the family might break down or a relationship might end. And again, if none of these situations are really linked to asylum or to an irregular border crossings, um, they're simply tied to the normal circumstances of life of any human being. And if all the policies in place do not allow for transitioning among these different statuses, or if they don't allow for easy renewals, or they impose overly demanding like criteria for renewal, then of course more and more people fall into irregularity or other types of legal precarity. So if all policymaking efforts instead focus on forced removal and deportation without addressing the real gaps in the policies, legislation, etc., in place in the member states and in Europe, then of course more and more people will end up falling through the cracks of these administrative requirements. And so yeah, this insecurity also translates into more people being easily exploited and exploitable in the labor market. They might be less likely to report abuses, get access to justice, or make use of services such as healthcare. And really, you cannot, if you will, deport your way out of this problem. Like there needs to be a real conversation on whether the regular pathways that exist, but also the possibility of transitioning between statuses and regularized status, one's own status in Europe. So going from a situation of irregularity to a situation of irregularity, uh, it's a matter of seeing if these instruments actually work, or are they even in place in the first in the first place. And I think with the return regulation fails to really have a look at these broader issues that create irregularity and only focus on these deportations.
Thank you very much, Davide. By the way, the proposed return regulation introduces stricter enforcement measures, including broader detention and increased surveillance. From a human rights perspective, which fundamental rights do you believe are most at risk, and what safeguards should be in place to ensure that migration management does not come at the expense of human dignity?
Well, yeah, this is a very good question. I think a number of fundamental rights are negatively affected by the return regulation. From human dignity, most basically at the very basic level, to the prohibition of inhuman and degraded treatment, to the rights of the child, but also non-discrimination, effective remedies, etc. I think the most obvious one it's the right to liberty and security, simply because the regulation expands detection practices and detention within EU territory, but also creates these return hubs abroad, so allows for extraterritorial detention in third countries other than like outside of Europe. So on the internally, what I would say now with the return regulation, member states authorities are allowed to conduct raids in private houses, but also other relevant practices, which will include places like hospitals or NGO premises or homelessness shelters, etc. And people subject to a return decision will also have an obligation to cooperate with their own expulsion, and even when the expulsion is not practically possible because of lack of cooperation from their country of origin, etc. So it's not something that depends on the person specifically. But also I would also highlight that homelessness is rather than as a vulnerability in this process is seen as creating the risk of absconding. So a homeless person would be detained because they're homeless, rather than helped and sent to appropriate services that would allow for them not to be homeless. Overall, the detention period would be of 24 months, up to 24 months, or 30 months in selected cases. But yeah, also with the when I speak about detection practices, these will likely normalize racial profiling, etc., because it's hard to imagine how member states authorities will be able to detect irregular migrants on what basis. How, of course, there will be checkpoints, etc., but ultimately we've seen that in most member states detection practices ultimately end up with racial profiling happening and being normalized by the authorities. And then on the external side, of course, the return hubs are big topic of conversation at the moment, especially because they while the regulation has a 1 year implementation period, the return hubs are already they will enter member states can already create these return hubs as when the regulation is approved. So the return hubs basically entail deporting third country nationals to a country that they have no connection to. It can be any country that simply accept to take these people, and it can also be done not on the basis of a legal agreement, but just on political arrangements. And as we know from recent experiences in Europe, these flexible agreements between between the EU or a member state and the third countries are usually lack accountability and legal scrutiny, etc. So it's hard to actually make sure that in these centers, in these return hubs, the human rights of the people that will be detained there will be actually upheld. Even the independent monitoring that was supposed to be in place in these return hubs has been weakened and will only be needed where there is onward return from the hub to another state. So overall, the regulation creates a very complicated picture that has an impact clearly on multiple human rights or fundamental rights under EU law. And as to the guarantees, of course, there needs to be clear access to remedies, because even the regulation does not provide for an automatic suspensive effect of the appeal in case of a return decision. It allows member states to have a suspensive appeal, but doesn't necessarily impose one. And again, the return hubs might act outside of this legal framework through these political agreements. So I think these are some of the most needed safeguards. But then again, I think ultimately a lot of the work that is needed is mostly for national and EU and European litigation on the regulation itself and on the specific issues that will come out of the implementation of the regulation itself.
Well, you highlight flaws in the way irregular migration is measured and interpreted. From your perspective, what role does improving our understanding and measurement of migration play in developing more effective and rights-respecting approaches to migration governance?
Yeah, thank you. This is also a very good question. I think my starting point with the point I raised in my commentary, my SEPS commentary, is based on the Commission's own argument behind the return regulation, which is only 20% of undocumented migrants, irregular migrants, are returned from Europe to their country of origin. I think that the percentage roughly fluctuates between 20% and 30% depending on the year. So in the Commission's own view, but also this has been a common view among MEPs, so members of the European Parliament and other and member states as well, is that because Europe is failing to deport, since the return rate is so low, then we need to make sure that we can adopt stricter policies that will make this rate grow. However, it doesn't necessarily this argument doesn't necessarily look at who's behind this 20%, 30%, like who are the people that we're talking about. Because, for example, we know that in a lot of cases, some people might actually receive multiple return decisions in a given member states. Some people might receive a return decision, then stay with a regular status for a while, and then receive another one because the status that they got expired in the meantime, etc., etc. So also, under the current return directive, which will be replaced by the regulation, there was also the possibility for member states to provide for permits on humanitarian or compassionate reasons. However, member states haven't necessarily done this, even where return was impossible to begin with. So behind this 20%, there's also people that cannot be, that at least under the directive could not be returned to begin with. So it's also an issue of return decisions that are issued too early and using, based on criteria that do not reflect the actual situation. Because if member states know that somebody cannot be returned to their country of origin, then that return decision should not have been issued to begin with. Or if somebody has health conditions or family ties, etc., then it is not it doesn't really produce anything positive if you issue the return decision. What it does, it's actually it lowers the return rate, because you create a broader number of people that have been issued a return decision. But then, of course, the practical reality is that you can only return 20% to 30%. So what I'm saying this because I think that these numbers have been misconstrued and misused by the Commission itself to justify the regulation, but also by other political actors for political purposes. And without truly understanding how return decisions work, how people might actually, have reasons to stay under international human rights law, but also under EU law, and yeah, other broader reasons, then it is not by making return policies or migration policies stricter that you would actually solve this issue. It is by actually taking like a real look at the evidence on the ground, seeing why people cannot be returned, what are the alternatives that are available to them, and see how we can improve these alternatives. What the return regulation does is it's basically going in the opposite direction. Now it's not even clear anymore in the regulation if member states can provide permits on humanitarian or compassionate reasons. It's likely it will be the case because it would be likely national competence in any case, but it's not clear anymore from the text. So again, there's this gap between the political narrative behind the return regulation and the reality on the ground and the rights of the people that will be affected by this regulation.
Thank you so much, Davide, for your very relevant insights. I mean, in particular, I was considering, well, of course, like the very recent decision of the European Parliament on the matter. And then, of course, I mean, you highlighted how much it is difficult, for example, to monitor the legality of agreements with third party states. In that case, I was thinking, for example, about the case of Italy, the very contested agreements with the Libyan authorities that have been developed throughout the years. So, yes, for sure, it is, I would say, a very hot topic, especially at the moment. So thank you very much for having, support, help us, and of course, like the people that will watch this podcast, having a little better, understanding of this phenomenon. So thank you again on my side.
Thank you for having me.
You're welcome.
Thank you so much, Davide.
Thank you.